The real news empowers us. It empowers us because it belongs to us. It doesn't receive any money, any corporate funding. It receives money from you, and it depends upon you because it belongs to you.
Reports indicate that Barack Obama has chosen Eric Holder to be his Attorney General. To find out more about Obama's pick, The Real News spoke to Bruce Fein, renowned constitutional lawyer and chairman of the American Freedom Agenda. Bruce served as Assistant Deputy Attorney General under President Ronald Reagan.
Eric Holder is a longtime Democrat, probably most well-known to the current audience as serving as Deputy Attorney General under then Attorney General Janet Reno, largely a background of prosecution, trial work, and then after he left the government, he served corporate clients in a variety of white-collar investigations and things of that sort. What does leap out to me from his background is this huge lacuna of any real sophistication of checks and balances, war powers, executive privilege, all of the constitutional issues that have so plagued the country since 9/11 and Bush-Cheney duumvirate decided that we were involved in perpetual warfare with every square inch of the planet a battlefield. Then perhaps the most alarming indication was shortly after 9/11, he said something to the effect, bureaucrats should get out of the way as we attempt to use military force against anybody and anywhere that we suspect is implicated with Al-Qaeda. A unilateral, narrow-minded view of the need for freedom and balance, even at the highest intensity of conflict, if we are to retain a republic and not descent into executive despotism under the banner of fighting international terrorists. And that is quite a alarming statement to make that seemed so shallow.
His most recent speech that he gave to the American Constitutional Society came out in all cannons blasting against the Bush administration for abuses of power in their pursuit of the war on terror. Are we to believe that he's changed?
Well, if you examine the particulars rather than generalizations about disagreeing with some of the Bush-Cheney excesses, for instance, saying that Guantanamo Bay should be shut.
Guantanamo Bay is an international embarrassment. Some of our closest allies now see this prison as a symbol of what America has become. We should close Guantanamo Bay, transfer the remaining prisoners to military prisons in the United States, and adopt an expedited and procedurally fair review process for determining who we prosecute for war crimes, detain as combatants under the laws of war, or, yes, release.
That suggests really semantical difference with Bush-Cheney rather than substance, because the flaw in the constitutional thinking is to believe that we are at so-called war with international terrorism, a tactic that means we will never have a war ending, and a concept that also means the battlefield is everywhere, and also indicating that we would then be authorized to hold people without accusation or charge indefinitely, without access to lawyers, as enemy combatants. That's the real issue. Where's our authority to have anybody at Guantanamo in the first instance? Because if you don't pass that threshold, you don't need to think about an alternate housing site for Guantanamo detainees. They shouldn't be there in the first instance, and you either charge them with crime and try them in civilian courts or release them. Anyway, these are specifics that Mr. Holder has not articulated, and he's had plenty of time to do so. They're not novel. I've done so. Many others have done so. And silence on that matter would be a source of some concern, because these are not eighth-tier issues in the legal justice system. They're front-page stories every day.
Perhaps Holder is most famous for his role in Bill Clinton's 11th-hour pardon of commodity trader Mark Rich. Rich had been on the FBI's most wanted list for fleeing from charges of tax evasion and making illegal oil deals with Iran during the hostage crisis. Here is Rich's attorney, Jack Quinn, testifying before Congress on Eric Holder's role in the pardon.
Mr. Holder told me that he had said to the White House counsel he was neutral, leaning towards favorable on the pardon. I had a subsequent conversation with the White House counsel, and I said to her that Mr. Holder had told me that. Her response to me, while not confirming his advice in so many words was, if Mr. Holder hadn't participated in the process or something to this effect, this pardon wouldn't have happened.
Mark Rich and his wife had made huge contributions to Bill Clinton or his library. Mr. Holder, who was then acting Attorney General, had submitted a memorandum saying that he approved the pardon, but it was not with great enthusiasm, but he certainly was not on record opposing this outrage, which certainly smacked of semi-bribery, if not worse. Now, what does that mean with regard to Eric Holder? Number one, it shows that he, at least at that moment, did not have the personal strength to subordinate politics and the desires of his superior, the president, to what would be any honorable application of the constitutional power of pardon. He capitulated justice to fortunes of the president. And that is quite worrisome because that has been the earmark of attorneys general largely under President Bush. That is exactly what we don't want in an attorney general. Now, the other element that I think is problematic about the Mark Rich pardon and Eric Holder's involvement is that we may be confronting a situation as Bush's tenure comes to a conclusion of wholesale pardons that Bush would issue to himself, to Dick Cheney, to those involved in criminal activity. It could be Ted Stevens. It could be now to Scooter Libby, a full pardon. Who knows how far down the food chain it could go. I don't think he'd reach Jack Abramoff, but maybe he would do that as well. And if that happens, what is going to be the moral authority for Obama and Mr. Holder to protest and say this is an outrage and try to deter its repetition? They, in my judgment, would almost have to be silenced because Bush would simply be bettering the instruction of Clinton and Eric Holder themselves. There's no doubt that under the Constitution, there's nothing that prevents a president from abusing the pardon power. It's not a question of legal ability to thwart a pardon. It's the moral authority you have to criticize and to make someone held accountable in the eyes of history by denouncing it. You may recall that President Ford's pardon of Nixon probably cost him his presidency in 1976. And all I'm seeing, the deterrent to abuses of pardons that comes from that moral authority to denounce misuse would evaporate with Eric Holder being the Attorney General because he has not stood against the kinds of outrages that would apply if Bush began to pardon himself and others involved in post-9/11 crimes.
This is the sort of thing we can build right now without anyone else's permission from the government or from the business community. It's the power's in our hands.
If we're not going to sleepwalk into more wars and into environmental disaster, we think we need to start with a television news network that won't bow to pressure and has the courage to seek facts. And that means independent economics. And that's why we need you.
Real hope means facing a complex reality. Your tax-deductible donation makes it possible. Please contribute. Visit therealnews.com.